A warm welcome to everyone who has joined here. Today, we are here to discuss what do I say? A session which will give you unmatchable benefits to your clients whom you are serving and give you clarity on this aspect. For this, we have a practicing advocate and a practicing chartered accountants. Two best combination who are directly involved with client and with the court to give you direct hand insight, ready-made food to eat, which you can directly give to your clients as a service. I would like to take a privilege to introduce Advocate Bhanu sir, who is a qualified chartered accountant, a LLB, and a BCom graduate. He has more than 17 years of experience. He practices in the litigation for indirect taxes, FEMA, IBC, and also does arbitration. He's been working into consultation of into indirect taxes with senior advocate Raghu Raman sir. Sir, and he enjoys reading and traveling. Sir, I welcome you on on behalf of KSCA and all others to enlighten us with this session, sir. Now, I would like to introduce you my principal, Siddhesh, like CA Siddhesh, sir. He has more than 2 decades of experience in indirect taxes. I've learned a lot from him. Only one thing I can say, he has very sharp memory. You ask him anything, he'll be there. And the USP of his Siddhesh sir is a family man. Like he knows to balance both personal and the professional life. This is very good quality to learn from you. Sir, today I welcome you on behalf of KSCA to join us and enlighten us with your knowledge, sir. Now I would like to hand over the session to Pradeep to take it forward.
Thank you, Rahul. So welcome all to this webinar on the Supreme Court judgment on safari retreats. So we'll try to, with the support of the eminent panelists, we'll try to decipher the Supreme Court judgment and what is the impact of it on the clients for the past and the future periods, whoever are involved in the construction of immovable property for their businesses. So to just understand the background, probably I'll put for the facts. Like we'll do like this, we'll put for the facts of the case and how it reached the Supreme Court, and then we'll pose the questions to the panelists based on those facts. Okay. So there was a company called Safari Retreats. So they are into construction of malls and renting it out to the shopkeepers who will pay rent and use that shops in the mall. Okay, so this is based out in the state of Orissa. So they have constructed a mall. Naturally, they have availed like procured goods and services, goods like cement, steel, architect service, etc. And then naturally they intended to avail, since the cost of goods and services typically in the construction of mall property is huge, they intended to avail ITC on it. So therefore, then they were faced with the block stumbled by the GST department, wherein they said that you are not allowed to avail ITC. So like before getting into why they are not allowed to avail ITC, etc. So basically there are two provisions in the GST law which allows or disallows ITC in relation to construction of immovable property. There is this section called section 17(5)(c), which restricts ITC on works contract service, which is used for construction of immovable property. Suppose if you are a business, then either you can procure all the cement, steel, iron, etc., and construct, or you can give it to a contractor who will do for you. So in that case, is the works contractor. So if you are using the services of a works contractor for the construction of your building, then you will not be allowed to take credit of it unless you are in the same business. Suppose if you are a real estate builder, then you may get credit. Okay, so that is one provision, which is section 17(5)(c). there is another provision wherein if I don't want to avail the services of a contractor and then I myself want to construct with the support of the laborers. So then you may not require the works contract service. You will procure all the goods like steel, cement, architect service, etc., etc. So that is covered by a section called section 17(5)(d). So there it says that if you are availing goods or services for construction, you will not get credit even if it is used for your business. So in both cases, so mind you, both cases 17(5)(c) and 17(5)(d) will not allow credit even if it is used for your business. The prime reason, at least as per the law, is that it is leading to immovable property. Okay, so with this background, Safari Retreats intended to avail ITC, and then they approached the GST authorities conveying their intention. So, which has been denied by the GST authorities, stating that so you are constructing a mall which is nothing but immovable property. So, and also yeah, before that, there is another exception in the GST law which says that if it is a plant and machinery, you will get credit even if it is a immovable property. And the exception to that is that if the plant and machine, if it is a building or a civil structure, it will not qualify as plant and machine. So in sum and substance of it is that whatever you may call building, you will not get credit. If it is a building or a civil structure, you will not get credit even if you want to call it as plant and machine. That is the provision as on today. So now the yeah, so now Safari Retreats intended to avail ITC, which is denied by the GST authorities. Then GST Safari Retreats approached the Orissa High Court, which is the jurisdictional high court, stating that the provisions which are existing, which is 17(5)(c), which restricts ITC on works contract service, 17(5)(d), which restricts ITC on goods or services used for construction. That should not be applicable to my case, because I am not using this building for myself. I'm using it for renting out. So therefore, they have made a plea that section 17(5)(d), which is applicable in their case, because they only procured the goods, they only procured the service, they have not appointed a contractor. Therefore, 17(5)(d) is applicable to them as per them. Therefore, they said 17(5)(d) should be read down. I think this Bhanu sir may explain it in detail, but as far as my understanding goes, 17(5)(d) should not be made applicable to my situation. So therefore, you should please read it down. So since I am into renting, but I am not using it for my own purpose, I am using for renting. Therefore, please allow me ITC. This was the contention, and then they have made another contention saying if you disallow ITC, it is against the certain articles of Constitution, etc., etc. So Orissa High Court has allowed this contention of Safari Retreat, saying that you are using this mall for renting it out. Therefore, meaning thereby you are generating GST liability when you get rent. So therefore, you can utilize the input tax credit, avail and utilize the input tax credit. That is the sum and substance of it. And then, yeah, they allowed the Safari Retreats to avail ITC. So naturally, the GST department is not okay with it. They approached the Supreme Court, and then so which led to submissions. So then after that, there are a lot of assessees who filed writ petitions in the same Orissa High Court, and then intervening applications by several other parties, making their own submissions as to why this should be allowed. And then naturally, department has made their own submissions as to why it should not be allowed. So finally, so now we are here, wherein Supreme Court last week has given a judgment on this aspect. Okay, so this is the brief background of the issue involved. So with this brief background, and with the support of our eminent panelists, we'll try to understand the answers for some of the contentious questions which are arising out of this judgment. So, sir, first to Bhanumurthy, sir. Sir, considering the facts of the case and the Supreme Court's comments and conclusion in this judgment, can one say that the phrase plant and machinery, which is mentioned in 17.5c, and plant or machinery, which is mentioned in 17.5d, so can we say that both of these phrases are same? So your thoughts, sir, please.
Yes. Thanks for the introduction, Pradeep. Only one thing just wanted to update your introduction is Safari, where it was dealt by the High Court of Orissa, it didn't touch upon 17.5c. It read down only 17.5d. Essentially, as summarized by you, when the input tax credit relates to goods or services or both for purpose of construction of immovable property, then 17.5d would come into picture. That is on construction on own account. I'm constructing the building or other property on my own. 17.5c would come in the case where there is a works contract involved. Works contract, as we know, it is a supply of goods plus supply of services, essentially, in a nutshell. So that is involved for the purpose of construction of immovable property. Then the credits are restricted, but both has its own exceptions. As you summarized, when it comes to 17.5c, if it is used for supply of further works contract services, the credit is allowable. And also when the works contract services are used for construction of immovable property, which may qualify as plant and machinery, then that also is eligible for credit. So what is plant and machinery is defined. As you mentioned, essentially apparatus, equipments, etc. are called as plant and machinery, but it specifically excludes the civil structures or building or land, and also telecom towers, pipelines outside the factory, etc. This is the definition which is there in clause 5 of section 17. So now, when we look at 17.5d, what it says is the goods or services are both procured for the purpose of construction of immovable property other than plant or machinery. The essential difference between these two is 17.5c says plant and machinery, which is defined. 17.5d says plant or machinery, which is not defined in the statute. So this is the essential difference which is there for the definition of plant or machinery, plant and machinery. So the other aspects which covers 17.5d is the construction should be on own account. What is own account? Again, not defined in the statute, but the Honorable Supreme Court tried to explain and interpret the provisions in the light of the various other provisions of the statutes. Okay. Now, coming on to the question which was posed, your question was essentially, is there any essential difference between plant and machinery as well as plant or machinery, which is there in 17.5c and 5d? I would say entire foundation of the decision of the Supreme Court, Honorable Supreme Court, was on this basis. See, what the Supreme Court said was that the clause C uses plant and machinery, which is defined, Clause T uses plant or machinery, which is not defined. Therefore, it will be not a correct position to adopt the definition of plant and machinery for the purpose of interpreting what is plant or machinery. What the Supreme Court keeping at that stage, it said the plant or machinery has to be looked at from a general perspective. So they borrowed the interpretation which was placed by various Supreme Court decisions on what is plant. So essentially, when we look at various decisions which are quoted in the Supreme Court's decision of Safari, plant is essentially one which is required for a person to perform his services or business activity, which is more essential in requirement. Without that, he cannot undertake his business activity. That becomes a plant. There are a number of decisions under the Income Tax Act, which in one of the cases where it relates to a chartered accountant profession, where it said books are also plant. Right. So that is the way which the Supreme Court took the definition of the plant. So adopting that, the Supreme Court said plant is one which has to be tested on the basis of functionality of that particular asset. So in this case, taking into consideration as to a building is for the purpose of the renting or leasing activity, which is ultimately liable to GST. Plant may also include the building which per se, which is essential for the purpose of renting or leasing activity. So therefore, plant and machinery, which is used in 17(5)(c), and plant or machinery, which is used in 17(5)(d), are quite different from each other. That's the view of the Supreme Court also. Siddesh, you want to add anything?
Thank you, Bhanu, for that clear distinction which you brought out from the judgment of the Supreme Court. The department on their side were vehemently arguing that, just for the understanding of all of us, they said that plant or machinery should be read as plant and machinery. They went on with the argument and they gave a reference saying that in the statute, only in one place there is a mention of plant or machinery, and I think in 15 places, right, Bhanu sir? 15 places, or I don't exactly remember that. And plant and machinery has been used in the statute.
Yes.
And therefore, since it is a error from the drafting of the act, and so plant or machinery should be read as plant and machinery. So there has been a drafting error which was mentioned in the submissions from the department. Then the contentions from the SACs were saying that initially when the draft law was made, then they have made a change of plant and machinery to plant or machinery. So there was a conscious decision of the drafters also that plant and machinery for C and plant or machinery for D, clause 17(5)(d), was consciously made. So the Honorable Supreme Court did not go with the argument that plant or machinery should be read as plant and machinery. And just certain references I would like to bring to the attention of all the audience here. They said that plant and machinery or plant and machinery would not have the same meaning, para number 44. And they said that while interpreting taxing statutes, it is not the function of the court to supply the deficiencies. So they said that if you have not defined, like there was a definition given to plant and machinery. So now if the statute has not given a definition of plant or machinery, they said that the courts can't step in to supply these deficiencies. So now the possibility may be that, which all are contemplating, is probably in the next GST Council meeting, they may take up to bring a definition of plant or machinery. Some school of thought is that they may make that plant or machinery or plant and machinery unlikely. They may retain that plant or machinery and try to give a definition. And even under the Income Tax Act, like Bhanu sir, that there have been many decisions in the aspect of what is a plant, and many decisions were there. When many decisions were for and against the SSC, there was an attempt made to give a meaning in the meaning of the definition plant. They excluded books, apparatuses, all there, excluding building. So when they made a exclusion for building within the meaning of plant, it went on to another set of litigations later. They said that the arguments taken in the Income Tax Act was, we never meant that it is a building. We always said that it is a plant. So exclusion of building within the definition of plant is not what it is. So it went into that. Then when the legislature uses the expression plant and machinery, only a plant will not be covered by the definition unless there is an element of machinery or vice versa. So this is one very good observation which is given, where they said that when we are reading plant and machinery, and if you want to put plant or machinery with readings in sync with that, you can't do that just by reading plant as plant and machinery. They have to be read together. And in the ordinary sense, it should be taken in the what it means in the commercial terms, since there is no specific definition provided. And to add on to own account, just to give a heads up to this, which will come in the subsequent discussions probably, is what is own account may be asked as a question, because 17.5D uses the word on own account, right? So since the own account also was not defined in the statute, the Honorable Supreme Court has said in para 32, saying that construction is said to be on taxable person's own account when it is made for personal use and not for service, or it is used by person constructing a setting in which business is carried out. So if you are constructing an office for which business is carried out, then it is on own account. However, construction cannot be said to be on taxable person's own account if it is intended to be sold or given on lease or license, which Bhanu sir made a mention on that. So in a nutshell, plant and machinery, plant or machinery is not one and the same, which the Supreme Court has laid down in this judgment.
Sure, sir. Thanks for the clarification. So so now we concluded that the phrase plant and machinery and plant or machinery are not one and the same. So now,
Yes.
now if you were to apply this to sort of larger audience in terms of different kinds of businesses, right? I mean, I may be a factory, I may be a service provider, I may be a construction company, etc. So, so if we see that in the context of somebody who has constructed a factory building or a factory office which is in the factory, or somebody who is in the hotel industry who constructed his hotel, or who has constructed cinema theater, or a mall, like what is the way we can, is there any way we can distinguish whether each of this can be considered as a plant, and if yes, what are the parameters? Siddheshwar?
Okay, that's a very
Emila.
good question.
Yeah.
Because though the judgment went on to discuss on that, you have tried to put a practical scenario, the way whether a factory building or factory office is whether we can consider that as a under 17(5)(d), or for that matter, hotel, cinema, theater, mall under 17(5)(d). Before we get into this aspect of this various types of examples which you have put on, there was a mention of even Anand Theatre case, Taj Mahal Hotel case in this judgment, and also Karnataka Power Corporation judgment in the case. So, what happened in case of Anand Theatre case and Taj Mahal Hotel case? There is a question which was raised whether a building used for running for a hotel or a cinema could be held as a plant. So there it went on to say building used for running of a hotel or carrying on a cinema business cannot be held as a plant because the word plant is given an inclusive meaning which nowhere includes buildings. And on this aspect, when the argument was being taken, there was another judgment which was taken into consideration of Power Corporation, whether the power generation station building is a plant for investment allowance. Okay, it's a power generation station. So in that context, what happened is the Honorable Supreme Court in this case, this is in the context of income tax itself, where these judgments have been quoted in the Safari Retreat case also. Generating stations has to be treated as a plant for the purpose of investment allowance, since these buildings cannot be separated from the machinery and the machinery could not be worked without such special construction. They were so integrally integrated that the building which is there for laying the particular water flow, the machineries and all, they were very much integrated. It was not that this building of power generation station was only for protecting that particular power generation station. Without these all elements put together, it couldn't run. So in that context, it was held that power generation station building is a plant. And in the same breath, in this judgment, they mentioned that the decision in the case of Anand Theatre cannot be applied because Anand Theatre was judgment by the 2-member bench, whereas Karnataka Power is a larger bench. So when we come to this aspect, there is a mention of a particular phrase in this judgment about the functionality test, which has been laid down in this judgment. The word plant will have to be taken by understanding the quality of what it is being used. They have brought in a concept of functionality test in this case. So in this case, as you mentioned, we'll take one by one. First is the mall, which was the case of a Safari Retreat, right? So mall for goods or services for construction of immovable property, if building satisfies the functionality test of a plant, it will be eligible for input tax credit of goods or services. But now what has happened is, in this judgment, they have said that it has been sent back to the Honorable Odisha High Court to determine whether the mall will qualify as a plant. And it says if the construction of the building was essential for carrying out the activity of supply of services, such as renting or giving on lease or other transaction in respect of a building or part thereof, which are covered by clause 2 and 5 of schedule 2, the building could be held as a plant. They have not concluded that when it is given for a rent, when the building is constructed on its own account for giving on a rent, there's no conclusion. That has to be again decided by the Honorable Odisha High Court. So that is in the context of mall. Now you had a question on factory office, factory building. I'll just make a finer thing about the factory building or thing is factory building. If we are want to say it is a plant, we'll have to satisfy the functionality test of a plant. And I think we may have to take a recourse of Karnataka Power Corporation If it is integrally related to that structure and other things, then it might fall within the meaning of plant for the factory building. Then in the same question, I would like to extend, in the factory, you may have a warehouse, right? Warehouse might be an aspect which might be within the premise, or we'll split this warehouse into two concepts. A warehouse is constructed by a person and then he lets it out. Then in that case, whether it will fulfill the test of functionality test of plant, and then it is eligible for credit, we'll have to look into the angle because it is being given on lease. Now the second aspect which will come in the factory building, I will in the factory adjacent to the factory building, I will construct a warehouse for storing my goods. So this warehouse which I have been constructed for storing the goods, again we'll have to find out whether this warehouse will fulfill the condition of functionality test. Again, considering whether it is in the context of Karnataka Power Corporation. So the decision of the Honorable Supreme Court is not that it is a one-line answer. It will have to be tested in each facts and circumstances. And as regard as cinema theater and hotel, in my view, again, considering the Anand Theatre and Taj Mahal cases, it may not satisfy the functionality test of a plant the way the judgment has been given in the Safari Retreat. Goods or services used for construction of cinema theatre or a hotel may not qualify as a plant under 17(5)(d). But if you are able to prove that functionality test considering the aspects of it, we'll have to see how the new developments will take place. Bhanu sir, your inputs on this.
See, as regards cinema theaters and hotels, what Supreme Court says is, because of Anand Theatre's decision, which was again considered by KPC, Karnataka Power Corporation, there, though Karnataka Power Corporation, the Supreme Court doesn't fully agree with Anand Theatre's case, but it doesn't exclude from the purview of the building not becoming a plant. See, what Supreme Court in Karnataka Power Corporation does is, other than what is covered under Anand Theatres, the other buildings have to be looked at from the point of view of functionality test. If that functionality test, as per that, it qualifies as a plant, it is essential for the purpose of business, then it would qualify as a plant. But it didn't touch upon the what is decided in Anand Theatres. Therefore, in this case also, in Safari also, the Supreme Court leaves out the theaters and hotels. That's the reason. So again, the question is, when can we again come back to that issue and determine on the basis of functionality test, it qualifies as a plant or not? It's a question we have to see whether it's possible or not. That is one aspect. See, on the other aspect which Siddesh rightly pointed out, whether it is a factory or a warehouse or any other building, we may have to see two aspects. One, when we construct such factory or a warehouse or a storage or area or a cold storage, is it on my own account? Then, whether if it is on own account, whether it qualifies as a plant. So plant, again, it is based on functionality test, which is beautifully put out by Siddesh. If it is essential for me to put my entire machinery into one place and make it workable, and that as per looking at how it has been interpreted in corporation, every factory building should qualify as a plant. See, this essentially what we are looking at is all these discussions is under 17.5D only. If we look at 17.5C, even if it is a factory building which houses number of missions, which is essential, 17.5C definition of plant and machinery clearly excludes civil structures or buildings. Therefore, the discussion which we are doing would not, for the purpose of functionality test, is not applicable to plant and machinery, which is covered under 17.5C. That we have to be very careful while understanding the issue. Yes, Pradeep.
Sure, thank you, sir. So basically, the key here is the functionality test, right? So whether a building, whether it is factory building, factory office, a mall, whether it is integral to the activity which is being carried out by that taxpayer, then it may qualify as plant and machine. Plant, if not, then it is not a plant.
Yes.
And one corollary question, sir. So in the judgment, Supreme Court has referred to a couple of cases of its own, like previous Supreme Court judgments, and said this is where we have analyzed plant, etc., etc. Now the Orissa High Court, whether the Orissa High Court has a scope to go beyond those judgments and also decide whether particular thing is a plant or not.
What Supreme Court has said in the conclusion paragraph is, so looking at the interpretation which is placed, which is discussed in detail here in this decision, on the facts of the case, now it would decide as to whether the mall in question before the Orissa High Court would qualify as a plant or not. Essentially, it is a mixed question of fact and law. The facts are before the Orissa High Court. The law which is being interpreted by Supreme Court has to be applied on that, and the conclusion has to be drawn.
Okay, so basically they should restrict to those judgments only while arriving at the conclusion.
Yeah, I would not say restrict, but they may also look into other decisions also, which may help them in doing so.
So how the Orissa High Court will interpret, we'll have to wait and watch.
And like moving on to this question, assuming Orissa High Court concludes that mall is a plant, so then in case in that mall there are cinema theaters also, and then what would be the fate of somebody who has constructed a mall? A portion of it they have rented it out, and then a portion of it is exclusive for the cinema theaters. So then should the ITC be allowed completely, or should be allowed proportionately? What is your view on this, sir?
Yes, sir. See, this has to be understood from the point of view of two provisions. See, I'm repeating 17.5C and D so that there is a clarity on our discussion and the message we pass. See, when we look at from the point of view of 17.5C, right, the mall which we construct, there's absolutely no scope for taking credit. What it appears from the bare provisions of 17.5C. So now we move on to 17.5D. That is the essential question before the Orissa High Court. So there, if we look at the decision of Safari, which was rendered by Honorable Supreme Court, the discussion as regards plant tries to specifically exclude the cinema theaters for the purview of plant. Therefore, if you are looking at a cinema theater as an independent unit, it may not qualify as a plant because of Anand Theatre's decision. But here, it is not a simple cinema theater which has been built. It's a mall comprising various other aspects also. It may house 2 or 3 cinema theaters. It may house 5-6 floors of commercial activities and 1 floor of restaurant activity and 1 floor of recreational activity. So taking into whole picture, so now there are 2 things would emerge. One, the owner builds the mall. So is he renting it out to somebody else to undertake all these functions, commercial activity, there is trading activity in couple of floors, and a couple of floors for another person to undertake the cinema activity, cinema show activity, or the restaurant's floor is being rented out to various people to undertake the restaurant activity and recreational facilities to somebody else. If that is the case, then it is meant for renting activity. The building as a whole, whether they house a commercial activity or a cinema or a restaurant, it is, for me as a owner of the mall, it is essentially for renting activity. So renting, leasing, it is indicated in the Supreme Court decision itself, it could qualify as a plant. Therefore, taking that scenario into account, I am eligible for the credit because it qualifies as a plant. Now, the other scenario, I am not renting it out, but I am undertaking on my own. This entire building or a part of the building is used for the business which I run. I run a business of showing cinema. Then the question comes whether this qualifies as for me as a, the plant. Then coming back to Anand Theatres, how it has been interpreted, in this case of safari retreats by Supreme Court, it might be difficult for that person to take the benefit as to it qualifies as a plant. So these are 2 scenarios. But in the second scenario also, I would say, see, if it is essential for the activity of running a business, then why not it could be termed as a plant? That as we discussed earlier, it is still to be discussed, deliberate, and may have to be the Supreme Court may have to interpret again.
Okay, so
This is my
got it. So in a nutshell, if somebody has constructed a mall comprising of commercial area and theaters, if he has rented it out on a whole, everything, then
Yes.
they will get credit. If they are if they are running on their own for the rented out portion, which is other than hotel, cinema theater or hotel, then they'll get credit for that portion. As far as this theaters portion is concerned, we may have to apply Supreme Court judgments in the past and decide.
Maybe yes.
Yeah.
But
Yeah.
here another issue which comes up is, so on what proportion would you segregate saying I should not be availing the credit? Is it on the day one which I am going to decide, or after putting that into use? Right? So for example, if on day one I rent it out to PVR cinemas, they conduct their shows. After 2 years, I'll take back, I'll start my own. Then should I have to go back and reverse the credit? These questions would have to be answered.
Yes, sir. These are some of the contentious questions.
Yes.
And moving on, sir. So
Siddesh, you want to add anything here?
See, one aspect which we have been discussing on 17.5C or 17.5D, right? 17.5C uses on the works contract aspect, just a bit of a deviation from the question which Pradeep has asked. Now, 17.5D uses the words goods or services, right? So, if you go to the meaning of services, the deeming fiction in 7.1, right? It gives reference to Schedule 2, which mentions that works contract is also a service, right? So, now if I subcontract the whole activity of constructing a mall, okay, and it is meant for leasing and it is not on own account, goods or services. Services includes works contract service. And plant or machinery, other than plant or machinery, then they have not used the word goods or services excluding the 17.5C clause. So if I subcontract that full construction to somebody and not on own account, will it still be eligible under 17.5D if it is a plant? Bhanu, just if you want to supplement on that subcontracting
Yes,
aspect.
that's a very valid point to be discussed. If we look at 17.5C, it mentions about works contract specifically. So when we look at 17.5D, it in general says goods or services are both. So one of the views which is which we if we apply the classification principles, the specific overrides the general. So that if you adopt that, the specific is 17.5C, which specifically mentions about works contract. The general category would not include the works contract. However, that may not be a correct answer also, or positions also, because 17.5D not just uses goods or services. It uses goods or services or both. So in this context, a position also could be taken, which has to be tested. If both is always a composite supply kind of services or supplies, which is essentially one of the important composite supplies works contract. If works contract is covered under both, obviously I'm covered under 17.5D also. That's the possibility which may have to explore.
Just to add on to that, Bhanu, like when I'm doing the for building on my own account, certain portions I would have subcontracted, right? A certain portion of my what you say finishing works, which will result into immobile property as a composite work supply works contract. So when I'm analyzing 17.5D credit, then whether this works contract which is happening in the part of this own own construction, should I exclude that then? So those are the issues which will start up in the next
Absolutely.
next issues which will
Next
come up
level of
probably litigations.
yes.
Pradeep sir, that's it.
yes. So so those probably will be answered when in the next round of litigation if it reaches this point. Yeah. So quick time check, sir. So webinar is scheduled till 7:30. Can we? Is it okay if we extend it for 15 minutes more till 7:40? Yeah. Also, there are a couple of questions raised by participants. So, do you want to take now or at the end?
Oh,
yeah. Okay.
How many
So,
questions more you have, Pradeep?
I have like 4 more questions. So maybe we can cut short it to 2. and then we'll take the questions from the participants.
If some of the questions which are asked by the participants would cover here, we'll cover this also.
Sure. Sure, sir. So maybe I'll cut short it to 2 questions and then we'll go to the participants' questions. So now in this judgment, Honorable Supreme Court has upheld the constitutional validity of these 2 subsections, section 75C and section 75D. So broadly, what would be the impact of it, sir, on taxpayers?
The impact would be that the statutory provisions as it is remains. There's no scope for any change in the provisions. It has to be applied as it is. But the Supreme Court has not stopped at saying the provisions are validity of the provisions are upheld. It has interpreted the provisions in a manner which would enable the assessees to take credit. Of course, the interpretation is more on 17.5D, not this absolutely. I would say there is no interpretation of 17.5C except saying it is a how the statutory provision reads has to be adopted. There cannot be a change in or addition or deletion to that. So when as we discussed last couple of minutes, so 17.5D how it has been interpreted, the Supreme Court, to put it in a summary, 1 or 2 lines, is construction of immovable property. If it is leads to construction of plant, you are eligible for credit. Construction of immovable property other than a plant, if it is not on your own account, then also you are eligible for the credit. But this is the to put it under a nutshell. So these 2 aspects are very important. Whether I qualify the building immovable property qualifies as a plant or whether it is on own account. These 2 have to be tested. Then only the credit eligibility or non-eligibility have to be looked at on each case facts basis.
So in the same vein, sir. So again, I think one of the petitioner has challenged the constitutional validity of section 16.4, which, if I'm not wrong, which talks about the timeline to avail credit the
Correct.
following year, November, November following the financial year. So again, that is also held that it is constitutionally valid. While there is no detailed explanation as to why it is like there is no reasoning which has been given, but what would be the impact of that?
See, the reasoning is there, may not be, I would say it may not be sufficient, or the court felt that there is no requirement of detailing the reasoning. See, impact of this would be in terms of the Finance Act 2024 amendment, which brought in 16.5 after 16.4 to give the benefit of credit for the financial year 17-18 till 2021. If the credits were availed well before 30th November 2021, they'll be eligible. That will take care of the credits which were delayedly availed till for 2021 financial year. But however, for the later periods, we had to follow the provisions of 16.4 as it stands today, subject to whatever amendments which may not be expected. But let us see how the law goes on.
Okay, basically status quo. So credit
Yes.
can be availed subject to the timelines.
There's one point I'd just like to make a mention. If you go to para 86 of the judgment, there's a new term which is come out now. While the judgment of the Union of India rightly contains that immovable property and immovable goods, hope Immovable property and immovable goods for the purpose of GST constitutes a class by themselves. Goods in the context of immovable. So what they have not mentioned what is immovable goods, defined or tried to explain what is immovable goods. But when you are reading the finer lines of the judgment, you will find this word. So even me and Bhanu, we have been deliberating from the day the judgment has come with other friends of ours. What is this term immovable goods now? You can have a look at para 86 there of the judgment. There you will find a mention of that.
The background to which we can find it in the submissions of learned ASG.
Okay.
There, what he tried to submit is the plant and machinery which is installed are immovable goods, and civil structure is a immovable property. That is the finer distinction which learned ASG wanted to bring in. That's how it has been. That's the background. But as you mentioned, it's a new phrase which has been coined.
Yeah.
At least I couldn't find what is the exact meaning where it has been defined. Immovable goods, how it has been defined.
Yeah, page number, not para 86, sorry.
Para
it is,
86. Page 86.
Page 86, para 58. Para 58 of page number 86, just for the benefit of all the this, you can have a look at that. Para 58, page 86. The last line which comes, the Union of India rightly contends that immovable property and immovable goods for the purpose of GST constitutes a class by themselves. So now we'll have to see how this phrase will be used by the department as well as the SSs going forward.
See, this we could relate it to the central excise regime. Wherever the machinery, various machineries are assembled at site, resulting in immovable property, that would not be construed as goods for the purpose of levy of the excise, duty of excise.
Narne Tulaman case and
so but all those decisions doesn't use immovable goods. They say once it is assembled, it becomes an immovable property.
Yeah. Right.
Yes, Pradeep.
Yeah. Yes, sir. So I'll take the question, sir. I'll read it out. And
yes, sir.
For your views. So Deepak Kothari says, can a company constructing a building and giving it for rent can now claim ITC of all goods and services procured post the judgment? Post this judgment, how do we advise our clients going forward?
Yes, sir. See, where as I summarized earlier, two things. One, you have to test whether it qualifies as a plant. Then you could also test whether it is on own account. So these two essential tests you have to meet to take the credit. It is not cumulative, it is independent.
So essentially, so essentially is for, sorry, sir.
So just to add on to Bhanu's comments, now, since whether it is a plant or not has not been answered by the Supreme Court, it has been sent back to the Honorable Odisha High Court, right?
Yes, true.
So now we will be in a dicey situation. What should I do? Should I claim? I don't know what are the principles which the Honorable High Court may lay down for qualifying as a plant, right? So one way to look at is we have this option in the form, claim it and then do a temporary reversal. Because you have the time limit to claim the credits for each financial year. So if you do a temporary reversal and hold on to that, your stakes are still there. But on the flip side of it is when the temporary reversal amount is ballooning bigger and bigger, you will have the letters coming from the department, which I think many of us have been facing, where SSCs who have not shown the credit which are ineligible, claimed and done a permanent reversal. For the past periods, department has been issuing, whether it is correct or they are not issuing show cause notice. They are some are using the word called endorsement. Some are telling some intimation. They are not giving reference to anything. They are giving reference to the circular which came saying that you had to do this temporary reversal for the credits which were not claimed also and reversed. In that context now, if you want to claim and do this as a temporary reversal, be prepared for notices from the department saying that why have you not still reversed when it is going on year? Probably when the things settle down and you want to claim and utilize later from temporary to thing, you can do that. But it's a long shot.
Got it. So even so the point is we have to avail temporarily and reverse so as to not to protect ourselves from the timelines basically.
Yeah.
Yeah. Okay.
And probably if you want to inform or whatever, you can take that step also.
Okay. And there is another question. Hari Kishan says if a landlord lets out the land to the hotel with the rights to construct the hotel at own plan and cost, will ITC be allowed? Hotel will be accounting the cost spent towards entire construction as leasehold improvements in the books of accounts. So a landlord is giving land to the hotel with the rights to construct the hotel as per the plan, as per their own plan. And when the hotel constructs this hotel, the whoever is the owner constructs the hotel, and they are accounting this as leasehold improvements, can they take credit? I think hotel, the Supreme Court judgment says you can't.
To answer this, essentially we have to look at what is construction. Construction has been defined in the statute. So wherever the activity of construction or a modification, etc., would for the purpose of the movable property construction, etc., if the amount is capitalized, then it becomes a construction activity which falls under 17(5)(c) or D. So leasehold improvements has been said by you. If it is capitalized, I think it has been the accounting standard requires you to capitalize it. So obviously you fall under construction, which is defined under 17(5)(d). Then the question comes whether it qualifies as a plant or not. Therefore, we will come back to the decision of Honorable Supreme Court, which clearly demarcates two buildings, hotels and cinema theaters, from other buildings. So looked at from that point of view, this decision has to be taken. So I would say hotels, as of now, looking at the bare reading of the Supreme Court decision, hotel may not qualify as a plant. That's one view as of now, which has been could be interpreted from what has been there in the Supreme Court decision.
Yeah. So before we conclude, I'll take one more question. So, there are two questions. I will just sum up. I think one is whether ITC can be availed on construction of commercial property, which is let out. That is one. And then there was whether there was an argument saying mall may not have a special requirement, hence may not qualify as planned. So I think for both of them, we may have to wait for the Orissa High Court judgment as to how the term planned would be interpreted from the perspective of those who are letting it out after constructing. So, any views?
Yeah, see, when we look at the decision of Supreme Court carefully, in one of the phrases, the paragraphs where it says that the building is essentially for the purpose of renting it out, then it may qualify as planned. And also another paragraph which Siddesh pointed out, para 32 of the decision, which says how to interpret on own account. When a immovable property is meant for the leasing activity or renting activity, which is liable for the outward GST, then obviously that is not an own account. So these two aspects have to be considered for the purpose of taking credit. So a mall, we cannot directly say mall because it may not have a specific technical requirements, doesn't qualify as a plant. It certainly could qualify as a plant because it is essentially for the purpose of renting it out. For the purpose of renting it, if I don't have a mall, I cannot rent it out. So in that aspect, it would certainly qualify as a plant.
Okay. So yeah, so I think so. Can we take one more question, sir, or should we? Okay, I think like final question will take, sir. So one is that the decision has not dealt with section 17(5)(c). Does that mean there is some scope for taking it again to Supreme Court? I think it may not, because if it is a building, then it is clearly excluded from the explanation which is applicable to 17(5)(c). You will listen.
Yeah, I would rather say it is not impossible, but certainly a difficult task. But this, as and when the issue comes up, we may have to litigate it again.
Okay.
On the 17(5)(c), just to add, it excludes telecom towers, right? On the aspect of telecom towers. Just to add on to that, it is an exclusion, means it won't fall within the meaning of plant and machinery.
Yes.
Right? So just to add on to that, on the telecommunication tower, there are transponders and other items which are fixed to it. Right? Tower is one aspect, but there are many apparatus or transponders or to pass on the signals. We have to attach those things to the tower. So just because the telecommunication tower has been removed from the meaning of plant and machinery, whether these other apparatus or the transponders which are attached to that, will it still qualify as a plant and machinery? So in that context, 17(5)(c), can we go into another aspect which the question has been raised? We'll have to see the nuances of how it has been dealt within the meaning of plant and machinery. There, if you see, they have given the word, defined what is plant and machinery as a apparatus, machinery or equipment. Okay, but they have not defined what again is an apparatus, equipment or a machinery. Then we'll have to go to interpreting what is an apparatus, what is a machinery, what is a equipment. When we have to go into 17(5)(c). It's not, it's a apt question which has been put also, whether there is some scope. I think again our advocates will take it to the next level and again try to vivisect that and say whether it is still possible.
Yeah, it's not impossible, but maybe difficult.
Difficult.
Yeah, see, to add on to the point of the transmitters or telephone towers, there was one circular which was issued recently by the CBC. What they say, the optic cable, fiber cable which is there, the ducts which are used, for the purpose of putting the optic fiber cable would still qualify as the plant and machinery.
Yeah.
It doesn't, is not blocked from the credit. So if you look at those interpretations, then obviously there are many things which are eligible for the credit, which may go out of the exclusion clauses.
But only
One more,
caution. Sorry.
one more aspect which I was looking at the question Q&A board, Rajesh Kumar raises is the decisioner is stating that the credit is not a right, but benefits conferred by the statute. What is the impact of this for the many cases where all along it has been argued that it is a right? Yeah, it's a good question. One of the important aspects, if we look at the decision, in the beginning portion of the decision, in the case of Safari, old decision under the central excise provisions, that is Eicher Motors, which has been relied upon. Of course, indirectly saying Eicher Motors was relied upon by the Orissa High Court to state that as the credit is a right. Unfortunately, there is absolutely no discussion on those aspects, which says it is a right. At the same time, though the decision in the Safari Supreme Court says it's a right, it's basically a statutory enabled thing. The discussion on those line of judgments, right, from ALD Motors and other things, saying it is not a vested right but as a concession. Those are also not discussed in detail to come to this conclusion. That is one aspect, which with due respects, another aspect is when we look at the constitutional amendment and also the objects and reasons of introduction of Constitutional Amendment Act as well as the CGST Act, that clearly mentions about the removal of cascading effect. These aspects of those argued and summarized by the court has not been dealt with. So still we have a scope for interpreting whether it is a right or a concession.
Yeah, it is in that para 58 which Rajesh is trying to mention. The right of ITC is conferred only by the statute. Therefore, unless there is a statutory provision, ITC cannot be enforced. It is a creation of a statute, and thus no one can claim ITC as a matter of right unless it is expressly provided in the statute. So again, the die case which is there, which is not being reasoned out why it is there. But on the aspect whether we should claim, we should be a bit cautious while advising the clients, or as we want to take the credits. The moment you utilize and later the judgments goes against you, you are at the fire with the reversal with the interests also. So whether you claim and keep it, and you want to see how the law will evolve, and then utilize that, precaution may be taken. That's it, Pradeep, from my side on this question.
Thank you, sir. Thank you for taking us through the intricacies of the judgment and patiently answering all the questions. Thank you, Siddheshwar sir, and thank you, Bhanu sir. I'll hand it over now to Sachin for the vote of thanks.
Thank you, Pradeep.
Thank you, Pradeep. Good evening, everyone. The judgment of the Supreme Court was passed on 3rd October 2024, and within a short span of 4 days, we are here discussing about this judgment. This wouldn't be possible without the support of our speakers. Thank you, speakers. Thank you, Advocate Bhanu sir and CS Siddheshwar sir, for enlightening us about this judgment and its impact in this informative webinar. Thanks, CA Pradeep, for the brief facts of the case, which made us to understand the discussion much better, and for moderating this session. Thanks to the president of KSCAA, CA Vijay Kumar M. Patel, and the team of KSCAA, whose efforts have been monumental in making this webinar a success. Thank you everyone who have joined this webinar which was intimated in a short span of time. Thank you so much for your presence. Thank you everyone.
Thank you, KSCA.
Sachin.
Thank you, Rahul, Pradeep, Sachin, for onboarding us to discuss this topic, which is debated. And from the day the judgment has come, we are seeing so many posts, various interpretations and views which are there. I think we have a long way to see what all interpretations will come. What we have given comments, others would have a different view. So we can't rule out that also. Thank you once again. Thank you, Bhanu, for your time.
Thank you, Siddesh. Thank you, Rahul. Thank you, everybody, for being logged in. And thanks for listening us patiently.
Thank you. Thank you, everyone.
Thank you so much.
Thank you, sir. Bye.